Okay, now let us deal with the actual bill itself. Now remember, the reason why you're drawing a bill is because you have, on behalf of your client, received a cost order, which means the loser, or however that cost order was gained, has to pay your client's costs. So how do we get it? Is we draft a bill for all the work we've done, and depending on the costs order, if it's a party and party costs order, we're going to draft it according to tariff, and we're only going to put those things that are reasonable and necessary to take the matter forward. If it's an attorney and client costs order that we are recouping from the opposition, we are going to put everything we did, including those things that were unnecessary to take the matter forward, and we're still going to base it on the tariff. Okay, and if we have an attorney and own client costs order that we're trying to recoup, we're then going to put everything we did. We're going to base it on our fee agreement, and we're going to attach our fee agreement so that we can, then what we do once we've done that bill is we serve that bill on the opposition. Okay, and if they don't want to pay it as it is and they consent to it and they want it to be taxed, what that means is they want some sort of oversight from a taxing master or a taxing mistress as to what we've charged is according to tariff and it's reasonable and necessary, for example. They want someone to check on us, then we will set it down for taxation. But our first thing is we need to do the actual bill. So the importance of drawing a good bill is obviously we want as much recovered from the opposition as possible so that we can get as much money back for our client that our client has paid us. Okay. Obviously, the prerequisite for drawing the bill of costs is that there must be a liability for costs. Somebody must owe us the cost. There must be a court order or a settlement offer or something that says that they have to pay our client back. And for that, we will then claim those costs and draw the bill. Okay. The following is a list of items that are not recoverable: unnecessary duplication of costs, misconduct, negligence. Remember, we've spoken all about this before. This is manufacturing costs or liability for costs where the cost didn't actually, charging for something that wasn't even necessary, or bringing the condonation application for a rescission application because you were negligent. Okay. Then we establish the nature of the bill to be drawn. We look at our cost order and we see, right, it's party and party costs for the entire matter. It's finished. Or perhaps it's an interlocutory application in the High Court, and for that there was a wasted costs order. So we look to see what bill it is. Okay, if we're in the Magistrates Court, we need to see, what scale are we on? Was our claim 0 to 12,000? And then from, I think in your notes it says 7, but there have been amendments, and every couple of years they amend the tariff. So we've got to keep checking that tariff to see if we're using the correct tariff for that time period. Okay, so we got to look, what was the judgment amount? Was it a scale C judgment? And if that's the case, I'm now going to follow the scale C numbers. Okay, then very important is if you don't have a very neat, properly kept file, you're going to find it very difficult to draft a bill. Because, for example, if you've got a consultation note that you had a consult with your client 3 years back, and in that you don't write the time or how long you were in consult for, you're going to find it difficult to remember how long that was for. And when the matter goes to taxation, the taxing mistress may say, well, Mrs. Fredericks, I would like to see your consultation note. And they're entitled to see that. Then she will have a look at my consultation note and she will say, right, it doesn't really show that you spent 30 minutes here. Or maybe you didn't even take proper notes in the consultation. And then that file note's not going to be a true reflection. So very important to keep notes of everything. Make sure your pleadings are separate from your correspondence so that everything's easy for you to draw your bill. Okay. The anatomy of the bill. The formal requirements for the bill are that you're going to have a number down the side for each item. You're going to have the date of the item. You're going to have a description of the item. And you're going to have the fees or the amount that was payable. Okay. So it makes things easier to deal with when you've got everything in order, and you're going to go from the very first date all the way through to the last date. Okay. On page 26 and 27, they talk about the differences in tariffs and how different tariffs came into play at different times. So, for example, on the 15th of June 2009, a new tariff came in that would have used certain figures, but that then was changed in July 2010. So for that period between June 2009 and July 2010, you're going to apply a certain tariff, which is going to have amounts, and then you're going to have to apply the new tariff for the next section. Okay, so making sure that you're claiming the right amounts on the tariff for the right times. Okay, now I want you to distinguish between a fee and a disbursement. Okay, a fee is something that my lawyer brain has done. So drafting the plea, making the telephone call, because I'm charging for my services. That was my services. Do you see that? But when I had to send my summons to the sheriff, and the sheriff served the summons, the sheriff sent me an invoice for their services, and I had to pay the sheriff. I disbursed money. That's a disbursement. Do you see that? Or I had to, for example, every time you send a fax, you're going to charge a disbursement amount, which is what it actually costs you to send out the fax. We can charge the fee for the letter, but for every letter, there's going to be a disbursement as well, which is what we have paid by having that fax sent. Or let's say, for example, we got a traveling expenses order, okay? A specific order that we're entitled to charge traveling. My time in the car is me. That's my service, my time for sitting in the car. Even though I wasn't doing anything lawyery, I wasn't able to do anything lawyery either. Do you see that? So I'm entitled to charge for my traveling time. But remember that there's wear and tear on my car. I have to put petrol in and all that. That is a disbursement. So I'll be able to charge for my travel time, but I will also be able to charge for my travel disbursement, and they will be separate. The important thing about a disbursement and a fee is that if I'm a VAT vendor, which means I pay VAT and I charge VAT, I can only charge VAT on my fees. I cannot charge VAT on a disbursement. Why? Because the disbursement is not something I did. I have paid out to the sheriff. I might have paid VAT on that disbursement, but that's all included in that disbursement. I can't charge VAT on it because that's not my service. Okay, do you understand that? So very importantly is that we have a distinction between fees and disbursements, but that if I'm a VAT vendor, I can charge VAT on my fees, but I cannot charge VAT on disbursements. Okay. Disbursements are things like council's fees, paying the doctor's accounts, sheriff's fees, advertising costs, all those sort of things. But remember that when you're doing your bill, you need to attach those disbursement accounts to the back of your bill to prove that you actually paid it, okay? Or to prove that that thing actually exists. Now, what happens if you can't find the proof of payment to a doctor? Guess what? The taxing master or mistress is not going to allow you to recover that money because you cannot prove that expense. So very important that you keep a proper file. Okay. Qualifying fees of expert witnesses. Remember I said you needed a specific costs order, and your specific costs order is going to tell you that you're entitled to charge for that expert witness. I'll give you an example. When I've received a bill and I want to check that it's all proper before my client pays it, is I look at the court order, and the court order says you're entitled to qualifying fees for the following doctors. And let's say it lists 4 doctors. But in the bill, 5 doctors have been put in the bill. and one of them they just forgot to put in the court order, guess what? They're not entitled to reimbursement of their costs. Okay, so very important that you check that everything in that bill is either allowed in terms of the tariff or they have a specific costs order for it. Okay, if while we're taxing, now let me tell you how taxation works. I serve the bill on the opposition and I set it down for taxation. What that means is that I, together with my opposition, sit with the bill in front of us, in front of a taxing master, and any problems the opposition have with my bill, they raise, we argue it, and the taxing master makes a decision. And the decision would be either to allow that cost and allow it to go through. Alternatively, she taxes it off. That's what we call, which basically means you're not entitled to it, so it will be subtracted from what you say you're entitled to receive. Okay. On page 28 and 29, they deal with the allocatas, and I'm going to do a separate video just on allocatas because that's quite a practical exercise that we're going to need to do. Okay. The terminology in the bill, be careful of saying things like attorney and things like that, because if you've got a party and party bill, the idea of putting a word like attorney almost makes it feel like it's attorney-client. And then the taxing master may tax that off. Okay. Delay in drawing bills. Not a good idea to delay drawing bills. Why? Because you need the stuff fresh in your memory to be able to get that bill out. Okay, now drawing a bill of costs is a long and tedious exercise. And for some people who don't understand the tariffs or don't understand legal costs, it's often quite difficult. So we have we have people called cost consultants. Cost consultants can be attorneys. They don't have to be attorneys. They are people who are experienced in tariffs, experienced in drafting bills of costs. And you can send your file to them. They will draw the bill of costs, and then you will pay them for drawing your bill of costs, a certain percentage of what the value is. Now, there's advantages and disadvantages of using a cost consultant. First of all, an advantage is you may not be an expert in costs, and you may not have the time to sit and draw a bill. They are experienced and have masses of knowledge when it comes to bills of costs, and they will be able to draw a bill much faster than you, and they have the time to do it. You've got a whole practice to run. Okay. The disadvantage is obviously that they were not part of the matter. So if you have a really badly kept file with really bad file notes, they're not going to be able to just remember certain things that happened, which you might remember. Oh, actually, we spent another hour afterwards in that, and I didn't put that in my file note or whatever. They don't have that insight knowledge. Okay, so that's the disadvantage of having a cost consultant. Now, can a cost consultant appear at taxation and assist you by taxing the bill of costs? The answer is both yes and no, because they can if they are admitted attorneys. If they are not admitted attorneys, they're not allowed to. Okay. The other thing that comes with cost consultants is that if somebody, like a cost consultant, has drafted a bill of costs, then you as the attorney need to sign a certificate only in the High Court, not in the Magistrates Court. But in the High Court, you have to sign a specific certificate saying that you have read the bill and that the bill is correct based on what's in your file. If you don't have a certificate signed, they will not tax your bill. Okay. On page 30, there's a whole bunch of practical hints that deals with drafting a bill, about keeping your file in good order, and that sort of stuff. Okay. There is a bit of a negative when it comes to drawing a bill when you are not very good at it. Okay, and that is that there are certain penalties which you receive from the taxing mistress or master when you fill in your allocata. Now, an allocata is, we're going to do it later, but it's effectively a summary of what you're entitled to get from the opposition. So you may have said, based on my bill, I'm entitled to 10,000 Rand from you, Mr. Loser. But when the matter went to taxation, the taxing master said, of that 10,000 Rand, there were a couple of items which you put in there, which maybe were attorney and client and not party and party, or were not specific costs orders and they needed to be taxed off. Then that amount will be subtracted from the 10,000 Rand which you say you should have got from the opposition. Okay? In addition to that, you will be getting a fee for drawing the bill. You will also get a fee for being at the taxation. Okay? And then there will be a total amount that's owed. So there's a way that we calculate the allocata, which I'm going to discuss later. But if you have had too much taxed off your bill, okay, the taxing master or the taxing mistress will say you are not entitled to a drawing fee. Okay, but it makes sense because your drawing fee, your fee that you are charging for drawing the bill of costs, how can you charge a fee when you don't even know how to draw a bill of costs? Okay, so if more than 20%, if more than 25% of your bill has been taxed off, the taxing mistress will say you're not entitled to a drawing fee. Okay, and that makes sense because you don't know how to draw a bill. Okay. You are allowed to settle a bill of costs. Now, remember I said to you that you will send your bill to the opposition, and only if they don't agree or they don't consent or settle the bill, then the matter will go before the taxing mistress. Okay? If they settle and agree to settle, then that is an agreement that, listen, we don't need to take this to the taxing mistress. We've reached agreement on what we will pay. Maybe they say, you know what, take 2,000 Rand off the bill and we'll be happy with it. And you are in agreement with it. Then both of you will sign a little thing at the bottom where you say, we have settled this bill and we agree to pay this much. You'll get it stamped by the registrar. But if the losing party or the opposition don't pay in terms of a settled bill, then that is not a court order. That's a whole nother agreement which you're going to have to issue summons on. So there are positives in that quickly we can settle this bill and hopefully they pay. But the negative is that you can settle the bill, but if they don't pay, you can't execute on that taxed bill. You will have to issue summons because it's basically an agreement that they've breached. Okay. So how do we get the bill to taxation? We do a notice of taxation, but we deal with it very differently in the Madge Court versus the High Court. Let's deal with Madge Court first. Okay. In the Madge Court, all you need to do is set the matter down for taxation on 5 days' notice. Okay, so you do a notice of taxation, and in that notice of taxation, you will say, kindly take notice that the plaintiff or the defendant, whoever has the costs order in their possession, the person who's claiming the reimbursement, will kindly take notice that the plaintiff is setting the taxation of the attached bill of costs down for the 11th of whatever, at whatever time, at whatever court, where they will, basically you setting the taxation down, and attached to that you will have the bill. Okay, you serve that on the opposition, you're going to file that at court, and on the day that you've said, you will then be in court. Okay. Remember that sometimes you're going to do a notice of taxation against people who are not attorneys. So you may want to sue your client for fees. So in your notice of taxation, you're also going to say, be pleased to take further notice that you may object to any item in this bill of costs, okay, and be present at the taxation. But if you choose not to object, then the matter will proceed as though it's unopposed. Okay. Doesn't mean it's unopposed because you still got to get it through the taxing master. So you will sit alone with the taxing master and she may pick out certain things in the bill that she doesn't like. Because remember, she has a discretion to allow or not allow a matter. So when she's finally finished with going through your bill, whether the person is there or the opposition is not there, she will make her final ruling on certain items. And then when it's finished and you've done the allocator calculation, she will stamp it. And then you have a stamped allocator. And we'll talk a bit later about what a stamped allocator really is. Because remember, we've said it's a certificate detailing and summarizing exactly what is owing to the person who has the cost order, who's seeking reimbursement. And the bit of a spoiler as to what's coming, it effectively is a court order and you can execute immediately. So you can issue a writ immediately based on an allocator. Okay, the High Court is slightly different. In the High Court, for years and years and years, it was dealt with the same as the Magistrates Court. Okay, but then Rule 70 was amended. And Rule 70's amendment basically said, before we set the matter down for taxation, we need to notify the opposition that we intend taxing the bill. So we start with a notice of intention to tax. Okay, so we say, kindly take notice that the plaintiff intends taxing the attached bill of costs. Okay, very importantly is that we say to them, for 10 days, for a period of 10 days from date of service of this notice upon you, you will be entitled to come and peruse my court file at the following address between the following hours. Okay, then you have another 10 days thereafter, so effectively 20 days, in which you as the person who's objecting to the bill of costs or any item in the bill of costs, you must file formal objections. Okay, so you will then set out at item 1, I believe it's attorney and client in nature, and this was a party bill of costs and I need it taxed off. Item 7, I'm not happy with this item because you have claimed for a doctor, which you didn't get a specific order for. Item 12, this item is unreasonably long, and because of that, I believe 30 minutes was reasonable for the consultation, and you've claimed an hour. I want 30 minutes taxed off. Okay. Once you have filed those objections and served them on the opposition, the person whose bill it is will reply to those objections. So they may say, item 1, I agree, you can tax it off. Item 3, I disagree with that, and I want the taxing master to make a decision. Then, once you have filed your reply, you will then set the matter down for taxation. But how much easier is it now? Because now the taxing master knows, so do you, and the opposition, that maybe there's only 3 items that the taxing master needs to decide. So it shortens the length of what a taxation used to be in the High Court. Okay, and then everything follows the same. You sit there, you tax it like you did before in the Magistrates Court. The taxing master makes a ruling, you fill in the allocator gets stamped, and you can execute immediately upon that allocator. Okay, so what's the difference here? The difference is in the Magistrates Court, you can go straight to tax the bill on 5 days' notice. So you can say today that in a week's time, effectively, because of member of weekends, this bill will be taxed. In the High Court, you have to start with a notice of intention to tax. The opposition do objections to your bill. You reply to those objections, and then you can get a date for taxation. And in the High Court, the taxation, your notice of taxation is on reasonable notice. Okay? Right. Remember we spoke about how in High Court you can tax interlocutory applications immediately. Magistrates Court, we have to wait until the end. We spoke about the certificate and that it's important that in the High Court, a certificate must be filed if somebody else, like a cost consultant, has drafted your bill. Okay. There are times, and this is on page 33 at 8.3, when you can consent to taxation. And by that, it means you are the person who's liable for the fees. You've seen the bill, you're happy with it, and then you file a consent to taxation. And in a consent, there is an example in your notes on page 37, where you basically say, I, the undersigned, Amanda Fredericks, maybe I'm a curator of an estate, in my capacity as curator of, or as trustee of, or whatever capacity on behalf of the respondent, hereby consent to the unopposed taxation of, and this is important, the annexed bill of costs. So you're actually going to attach the bill that you're consenting to the taxation of. Okay. Then we've got the next paragraph that we're going to deal with is taxation itself. And in taxation, the pretty much golden rule is that the taxing master has a discretion. Okay. Remember, I explained to you what is taxation. Taxation is in a litigious matter, because remember, we're only dealing with litigious matters now. We have a taxing master, and we've got the two people who are involved in the litigation. The person who wants reimbursement has submitted a bill, and the opposition is complaining about something in the bill. So they're saying it's not according to tariff, or you've used the wrong tariff, or you've put something in there that wasn't a specific costs order, or whatever. Okay, then the taxing master is going to make a decision based on their discretion to allow it or to disallow what they've charged. And the whole purpose of a taxation is that it can reach finality as to what amount is owing. Fill in the allocata, which is a certificate of what we can claim from the losing party or the party who is liable to us for costs, so that we can execute. Okay. So now what happens if all of a sudden the taxing mistress has made some really strange ruling? Okay, so they've allowed something which shouldn't have been allowed, or they disallowed something which should have been allowed. Is that the end of the road? Well, it never really is it? Because we can appeal it. But in this case, remember the difference between appeal and review? I always remember that review is based on someone's mind, isn't it? It's about the decision-making process, a review. It's about the person itself. And so because the taxing master has a discretion, okay, if we are unhappy about something they've done, we will review that decision. And that review will be decided by a magistrate or a judge, depending on which court you're in. So what are the grounds that we can review a taxation? Okay, we can review a taxation if we believe that and I want to just point you to it. It's on page 38. Okay, if we are wanting to review a decision of a taxing mistress, then we need to base it on the following. Okay, either the taxing mistress acted upon a wrong principle, or she didn't exercise her discretion properly or at all. She disregarded factors or principles which were proper for her to consider, or she considered ones which she shouldn't have. She incorrectly interpreted the rules of law, or she misdirected herself when the decision was clearly incorrect. Do you see that's all about mind? It's all about her discretion and that she hasn't applied it correctly. Okay, and so because of that, we can take it on review. But here's the clincher, is that you cannot take something on review if you didn't object to it. So if you decided not to object to something and the taxing mistress just allowed it to go through, you can't get back to the office and then decide, I should have objected to that, and try and review it. You must have done something. Or the taxing mistress must have done something on her own accord, which you disagree with. Okay. Back to the taxability of costs on page 34 of your notes. We've already spoken about how in the magistrate's court, interlocutory applications, we can only tax those at the end of the matter. In the High Court, we can tax it immediately. Okay? There are sometimes unwritten rules about taxation. So we have a really lovely chief registrar and taxing master, and he's based in Grahamstown. And what he does is every couple of years he publishes guidelines for taxation in the Eastern Cape. And he does that based on what his taxing masters and mistresses have said has come up and which isn't governed by something else. And I'll give you an example. When you're drafting a discovery affidavit, you obviously have to go through your file again to peruse what to discover and what not to discover. For years and years and years, people were saying they re-perused the file and were charging a perusal fee, which in the High Court is 59 Rand 50. They were charging a perusal fee for each page in the file. Now, if your file's 10,000 pages long or thick, that's a lot of money to re-peruse. And it was always a bone of contention at taxation, because people were saying, well, you know what, when you get to a doctor's report that's 200 pages long, you don't peruse every single page to decide whether to discover it or not. You're going to look at the front page and you're going to realize that you should discover it or not. So a guideline was issued by Denham Krokwana, our main registrar, where he said, in matters where there is a re-perusal of the file contents for discovery purposes, re-perusal will be charged at 50 pages per 15 minutes. So it's not in a rule anywhere, it's not in a case anywhere, but it's in our guidelines for the Eastern Cape. And so each division will have their own unwritten rules or guidelines when it comes to taxations, which we can follow. Okay. Right, on page 36 at 9.6, it deals with those penalties I was telling you about. So in the High Court, it says the taxing master may, if he is satisfied that fees are being charged in a party-party bill of costs for work that wasn't done, or for work which fees are to be charged on an attorney and client scale, or are excessively high, they can deny the attorney the fee for drawing the bill of costs. Okay, and that would mean that 20% of the bill should have been taxed off. And if more than 20% is taxed off, you don't get your drawing fee. Okay. When we deal with an appearance on taxation, what we're saying is who can appear at taxation? Well, the answer is people who can appear at taxation are admitted attorneys. In the High Court, a candidate attorney is not allowed to appear anyway, so they can never appear at taxation. Okay. Page 37 deals with your consent to taxation. Page 38 deals with the review of taxation, okay, which we've already discussed. And page 11 deals with recovery of costs. Okay, now when we're dealing with recovery of costs, what does that mean? Okay, so I have a cost order. I've taxed my bill. I've drafted my bill. I've taxed my bill. How do I get the money out? Well, the minute I have an allocator, that's an order. And I can issue a writ immediately and I can execute. And that's how we recover costs. Legal aid matters. I've spoken to you about that before. Sometimes what happens is really dodgy, is that somebody is taken on a legal aid matter, so they're instructed by legal aid to help with a matter, and then they make the legal aid client pay them the difference of what legal aid is not paying them. You can't do that, obviously. And if you're dealing with a legal aid instruction, you do need to notify the other side that it's a legal aid matter. Okay. Right. The next two videos are going to be two very practical videos. The first one dealing with the allocator and how to complete it, and the second one dealing with the statement of account to your client. Other than that, I think we've covered most of the if not all, of the theory.